Thank you all for coming. There's going to be lots of bitterballer for everybody after this. At least 3 per person, I think. I'm first going to talk for 10 minutes about my dissertation called Frontiers of Equality in the Development of EU and US Citizenship. And in my thesis, I try to understand EU citizenship and what it is and what it's becoming by comparing it to US citizenship and its development. Now, both are federal citizenships. A federal citizenship is always layered with the citizenship of a state or member state. For instance, and you can't have one without the other. For instance, in the US, everyone who has US citizenship is a US citizen and they're a citizen of the state where they reside. In the EU, everyone who has the nationality of a member state is a national of that member state and they are an EU citizen as a result of that. Now, I say that the most important aspect of citizenship, as opposed to nationality, is not what sovereign state you owe allegiance to, but rather the legal claim to equality that you can invoke is the most important thing, the legal claim to equal treatment before the law. And I say that federal citizenships in both the US and the EU work in largely the same way, which enables a comparison. The history of both of them shows how federal citizenship develops by constantly advancing the frontiers of equality in the face of institutionalized inequality. Classes of citizens who are historically treated unequally by states are able to invoke their federal citizenship as a source of equality. The first frontier of equality is always the treatment of citizens of one state who are traveling or residing in another state. But the ultimate frontier of equality, I say, is how states treat their own citizens or nationals. It is on this level where federal citizenship becomes really interesting, because if citizens can invoke their federal citizenship against their own states, then that means that states no longer have the sovereign freedom to make laws that treat certain classes of their own citizens unequally, even if it is the will of the democratic majority. And the comparison of the US to the EU on this frontier brought me to a very surprising conclusion, which I will, of course, get to at the end. Now, in the history of the US, the most prominent form of institutionalized inequality that I deal with, which is not to say that it's the only one, is the treatment of African slaves and their descendants, the African Americans. Before the Civil War, of course, slavery was ultimately abolished in the northern states, and African Americans could even be free citizens of those states. But slavery was actually so entrenched in the entire federal order, with a provision in the US Constitution called the Fugitive Slave Clause, that the only equality that all African Americans were entitled to was an equal liability to being claimed and recaptured as a fugitive slave, no matter where in the US they lived. This was not only patently unjust, but it created a tension between the free states and the slaveholding states that led to the American Civil War. After the Civil War, the original flaw in United States citizenship was resolved by making it more strongly vertical, to use a term of mine. The 14th Amendment was ratified, which said that everyone born on U.S. soil is now a citizen of the U.S., first and foremost, and a citizen of the state in which he or she resides, at least in theory, entitled to the privileges and immunities of citizenship and the equal protection of the laws. But for over a century, the legacy of slavery continued. African Americans were second-class citizens, which means that they had the formal status of being U.S. citizens without any real rights to go along with it. Slowly, starting in 1941, the Supreme Court started to grant equal rights to U.S. citizens who were crossing interstate borders, saying that they could not be segregated. But U.S. citizenship would finally cross the final frontier of equality in 1954 with the Supreme Court decision Brown versus Board of Education. In this case, the Supreme Court ruled that the school board of Topeka in the state of Kansas was no longer free to force African American children to attend segregated schools, because these children had the right to grow up as equal citizens. So this is where U.S. citizenship becomes really interesting, where it intervenes between a state and its own citizens. The struggle for real equality for African Americans is far from over, of course, but these developments meant that they finally had a claim to legal equality based on their U.S. citizenship. Moving on to Europe, in Europe, the first historic inequality was simply the restrictions that these states put on each other's nationals with the requirements of immigration law. Actually, most of the world knows this system of immigration law, meaning that if you're an alien, you have to ask for a visa, you have to ask for permission to be allowed to stay in another state of which you don't have the nationality. So one of the cornerstones of the European Economic Community was the freedom of movement of workers. This was an equality for citizens crossing borders, which means they no longer have to ask permission or apply for a visa in order to stay there and work there. So that was the first of three frontiers of equality in Europe. In 1993, at the same time as the foundation of the European Union, the status of EU citizenship was introduced for all the nationals of the member states. For years, commentators wondered if this really added anything to the freedom of movement of workers, if it wasn't just a new label on an old package. But the next frontier of equality that EU citizenship advanced was equality for EU citizens who were moving to other member states, but who were not going there to work, something that states were often afraid of, economically indigent citizens who were then at risk of going on social assistance. In 2001, the Court of Justice of the European Union helped to advance this frontier further, in the case of a French citizen living in Belgium who had applied for social assistance there, by pronouncing that Union citizenship is destined to be the fundamental status of nationals of the member states, not their status as worker, not their status as economically active person. In the course of the 2000s, it was increasingly settled that mobile EU citizens, ones who crossed interstate borders, could use their union citizenship as a source of rights. But this left behind the so-called sedentary EU citizens, the ones who stayed home in their own member states and did not cross any borders. For instance, in the Netherlands, a Dutch citizen who lives in the Netherlands and hasn't crossed any borders, if they have a partner or spouse from outside the European Union, they have to satisfy really strict requirements of Dutch immigration law. The Dutch partner has to earn 1,650 euros gross monthly, has to have a contract that's valid for a year into the future, which almost nobody gets anymore. The foreign partner has to take a basic exam of Dutch language and familiarity with Dutch culture in their home country. All this before the foreign partner will even be granted a visa to come to the Netherlands. So if a Dutch citizen is not able to satisfy these requirements, or their partner is not able to satisfy it, what can the Dutch citizen do? One solution is that they can become mobile themselves. They can cross borders, and then when they go to live in another EU country, the rules of EU law and freedom of movement say that their closest family members get an automatic right to stay with them in another member state, with no integration test required and no strict income requirement. Now, Dutch people, usually call this the Europe route or the Belgian route. Dutch citizens usually go to Belgium to do this. This is not because they're shopping for another country. It's not because Belgium is necessarily more favorable. It's because a Dutch citizen, by virtue of being in a member state of which he does not have the nationality, activates these rights of EU law. And for instance, I have a lot of clients who come from Britain, who follow their Europe route via the Netherlands, because EU law applies to them there. Finally, and leading to the final and most surprising conclusion, what about the most vulnerable sedentary union citizens, the ones who are unable to just get up and go and move to another member state? This is where it gets really interesting. In 2001 and 2013, the European Court of Justice made two pronouncements on the rights of children who are EU citizens, whose parents were irregular migrants from outside the EU. In the case of Ruiz Zambrano, the children were born with Belgian nationality, living in Belgium. They had not crossed any borders. Their parents were Colombian. The court said that without their parents getting a right to stay there in Belgium to take care of them, the children's citizenship would be effectively taken away from them. The children themselves would be effectively deported from the EU if they had to return to Colombia with their parents. Likewise, in the case of Lokpa, the court said a similar thing about the French children of a Togolese mother, said essentially, or implied, that if their mother did not get the right to stay with them, these children would effectively be deported from the EU. They'd be deprived of their EU citizenship. So this leads us to the most surprising conclusion in the comparison between EU citizenship and US citizenship. Because US citizenship doesn't have this at all. US citizenship does not guarantee children who are US citizens the right to have their parents with them. But what EU citizenship guarantees these children, these Belgian and French children, is not the right to be some sort of undifferentiated status of European. It's not to do with a sort of creation of a European national identity. Because these Belgian and French children are European, they get the right to grow up Belgian and to grow up French. So EU citizenship is actually about maintaining unity in diversity. It's about actually anchoring EU citizens in their own member states, giving them the opportunity to lead an integrated life there and to grow up as equal citizens to, for instance, Belgian children who have Belgian parents and French children who have French parents. So that was the most surprising of my conclusions. That was the one case in which EU citizenship goes farther than US citizenship. Thank you very much for your attention. Moeten we een paar minuten aanspreken?
Ja, is wel handig. Is wat je kunt verliezen. Hoeveel formulieren?
Nee, formulieren.
Zo wordt je gevraagd om dit voor te lezen. Ja, zo vast. Succes.
He's short. By authority of the Rector Magnificus and the doctorate board of this university, I shall, during this hour, in order to obtain the doctorate, publicly defend my thesis entitled Frontiers of Equality in the Development of EU and US Citizenship. I entreat all of those who wish to voice criticism of the contents of the thesis to do so in a truthful and lucid manner, so as to provide an opportunity for an ordered exchange of views.
Ladies and gentlemen, welcome to this special meeting of the Doctoral Board of the University of Amsterdam on the occasion of the PhD defence of Mr. Bierbach. And I would like to introduce the first opponent and welcome Professor Christoph Schoenberger, who has travelled to us today from the University of Constance. He is Dean and has the Chair of Public Law, European Law, Comparative Constitutional Law and Constitutional History from the University of Constance. Professor Schoenberger, you have the word.
Thank you very much. Dear Jeremy Bierbach, I want to say what a pleasure I have to be here today at this festive moment and to say the pleasure I have in reading your dissertation. We will convene afterwards, but I already want to express this pleasure. Now, I want to challenge you a little bit. You rightly claim in your thesis, in your remarkable book on a comparison between union citizenship and EU citizenship, that there is a certain verticalization of union citizenship underway in some landmark decisions like Rockman or Sambra. But the extent of this verticalization is still very much uncertain, and that's where I want to lead you with my question. By drawing on the US experience with slavery and its aftermath, you may underestimate a little bit the importance of the fact that EU citizenship remains still derivative, that it is still based on member state nationality, and that EU legislative competences in matters of nationality and alien law remain extremely limited. Here, the US experience with the imposition of certain rules by the federal court system may be somewhat misleading. In the European Union, with the strong bureaucracies of the member states and the continental tradition of written civil law, important changes in the law of foreigners, like the rights of third country spouses you very much insist on, cannot be implemented by European court decisions alone. You need legislative intervention at some point, either at the national or at the European level. Where in the US, federal citizenship is a separate status, dealt with by federal courts and federal authorities, in the EU, fundamental changes need at some point a confirmation by EU legislation in order to be effective, to effectively shape the behavior of the member states' bureaucracies. Here, the very impressive comparison of your book with the US may sometimes be misleading when we try to understand European citizenship. What do you think about it?
Highly esteemed opponent, hochgelehrter Opponent, thank you for your kind words. I'm likewise very honored to have you present on my committee and as an opponent. As you know, as I said in my book, your book Unionsbürger was probably the #1 source for my book, and your discussion of Bundesangehörigkeit, which I translate as federal citizenship, was very formative for my ideas and for my methodology. Thank you for your very interesting and challenging questions. First of all, as to the fact that EU citizenship remains derivative, yes, I agree that this is the most prominent difference between EU citizenship and US citizenship. US citizenship is truly the primary status there. It has its own status, and it is granted independently. And state citizenship in the US is derivative from US citizenship. In the EU, it's still the other way around. The member state nationality exists as the a priori status, and EU citizenship exists as the derivative status. As to that, I say, by comparison to the US in its phase before the 14th Amendment, because before the 14th Amendment, US citizenship was exactly the same. State citizenship was the a priori status, and US citizenship, was derived from it. And in my section, The Failure of Horizontal Citizenship, at the end of chapter 4, I believe, of my thesis, I describe where it exactly went wrong with a horizontal citizenship in the United States, because it was destined to fail precisely because of the strains of slavery and racism through which a free citizen of New York who happened to be African American was in theory a United States citizen and in theory entitled to the privileges and immunities of citizenships in other states. But of course, since it was a horizontal citizenship based purely on non-discrimination of citizens of one state traveling to another state, that would have meant that a free African-American citizen of New York would never have been entitled to equality in the southern states. And I say that if a horizontal citizenship possibly could have worked in the United States, but in any case, the first condition for that would have been the abolition of slavery and the introduction of a strong and compelling human rights standard that all of the states shared. So I suppose what I mean to say by that is that in the EU, the fact that EU citizenship is still derivative from member state citizenship does not make it any less compelling, and it also does not make it ineffectual probably because, especially in the post-war European order, where the prominence of human rights has been recognized, not least with the promulgation of the European Convention on Human Rights, all member states of the EU do share a common basic human rights system. No member state can introduce a system of segregation or apartheid. No member state can introduce a system of slavery, which means that in any case, as to the recognition of the rights of EU citizenship of a national of another member state, there can never be a problem. There can never be a holdup. And in fact, the European Court of Justice has been very activist about this in insisting that there can be no secondary conditions for recognition of the rights of EU citizenship, starting in Micheletti, of course, prior actually to the actual introduction of EU citizenship, but also later on. Also, you touch on the fact that in the EU, the implementation of EU law is dependent on the member states. They do not. There are no EU. There are no EU courts on the ground in the member states. A citizen who wants to make an appeal to EU law cannot go directly to a federal judge in the same way that a U.S. citizen who has a complaint based on their U.S. citizenship can. The EU citizen is utterly dependent on member state institutions for the protection of her or his rights as an EU citizen. If an EU citizen feels that her or his rights as an EU citizen are being violated, he or she has to go to a court of the member state, or he or she has to hope that the legislature of the member state will correctly implement EU law. Again, in my conclusions, I touch on the fact that that is related to a very different very different cultural background to the development of the EU relative to the U.S. That, of course, in the U.S., the federal government was always the relationship to this day between the federal government and the states and the state governments is still very antagonistic in the U.S. Therefore, a U.S. citizen cannot expect to obtain justice from a state court, cannot expect a state court or a state legislature to adequately protect their rights as an EU citizen. It would be as if in the 60s, an African-American citizen of Mississippi would have had to go to a Mississippi state judge to obtain protection of their rights under the 14th Amendment. So in that case, it helps to have a separate federal system. In the EU, however, I'll finish my comment. In the EU, however, there's much more of a consensus between courts and legislatures about the implementation and application of EU law.
Thank you.
Okay. Great. Thank you very much. The next opponent is Professor Ruud Janssens of this university, Faculty of Humanities, and he is Professor of American Studies.
Dear candidate, I would like to express my admiration for the amount of work you put into the dissertation. You studied an overwhelming amount of court cases and literature on citizenship throughout the centuries, and you've created a coherent and interesting argument. As an historian, I was pleased to see that on page 6 of the manuscript, you state that you follow the historical method. Well, it's the manuscript, not the book exactly, but the
Page numbering is the same.
Oh, so, okay, good. According to you, the historical method is following a chronological line of development. I'm not sure if many historians would describe their work as just presenting a chronological line. The remark about a line of development sounds a lot like you see progress through time, which is problematic for most historians as well. In fact, I think it's a pity that you did not take the opportunity to discuss an important difference in approach between legal scholars and historians. In your dissertation, you place yourself squarely within the Anglo-American tradition, in which jurisprudence is essential in understanding the development of law. Historians, though, want to study historical phenomena in the context of contemporary society, to understand how different other time periods are from us. Let me offer you an example of what I mean and formulate a related question. In Chapter 2, you write about the development of legislation in the United States and how British subjects were turned into American citizens. You write about the progress of how a federal concept of citizenship was stated in a limited form in the Articles of Confederation, expanded in the various Naturalization Acts, and then in Chapter 3 you focus on the legislation surrounding slavery and African Americans. You conclude that chapter by stating, on page 148, at the very least, the necessary first steps to make a horizontal United States citizenship to make a United States horizontal, to make a horizontal United States citizenship work, would be the abolition of slavery and the imposition of voluntary adoption on the part of all the states of common human rights standards. On page 193 you state, the Articles of Confederation and the Constitution, moreover, were rather stingy with their endowment of equality, specifically for the citizens of the United States, severely, and maybe you mean separately here, or of the United States as a whole. What I miss in your analysis is the Bill of Rights. The states only wanted to prove the new United States Constitution if 10 amendments were accepted. The Constitution established the setup of the American government, and the Bill of Rights guaranteed the rights of individuals within each state of the United States, on topics such as freedom of religion, freedom of speech, and the right to bear arms. The Bill of Rights was a recognition of the rights of, and I quote, the people and persons. My first point is that even though the word citizen is not used in the Bill of Rights, these are rights clearly intended for the people of the United States, and therefore there is apparently a concept of citizenship at a federal level. My second point is that even though there is a concept of American people and their federal rights, this concept is different from the rights we nowadays might expect. Not only African Americans are denied rights, but so are other people. When you look at for instance, voting rights for Americans, these rights were originally limited to mostly only white male landowners. In 1856, voting rights were granted to all white men, and women were only were only to vote from 1920 onward. Yet in 1922, the Supreme Court denies citizenship to the people of Japanese descent. And in 1923, people from India are also excluded. So, in conclusion, my questions to you are, first, why do you believe that the Bill of Rights was not an expression of the idea of the federal rights of American citizens? And second, does your focus on duplex citizenship not deny the complicated nature of the historical debate about the concept of citizenship?
Highly esteemed opponent, hooggeleerde opponent, thank you for your kind words and for your challenging question. It's very interesting, in fact, that you cite on my quote on page 148, which actually just came back in my answer to the previous opponent, where indeed I said, I made the statement that to make a horizontal citizenship work, it would be necessary to establish a common human rights standard. As to your question, your very good question about the Bill of Rights, that is a very good question. I did touch on, I could probably not find the page right now, I did mention the Bill of Rights and the role of the Bill of Rights in the promulgation of the Constitution. In that at the time, and yes, the Bill of Rights in a certain way did express a form of equality. I suppose I did not spend more time on the Bill of Rights because, as I also said, in the way it was seen at the time it was promulgated, the Bill of Rights was seen primarily as a limitation on the power of the federal government. At the time, the reason why a faction of the Constitutional Convention wanted to add on the Bill of Rights was because they had an extreme mistrust for the federal government. At that time, the states were viewed as the repository, the natural repository of rights. It was something, I suppose, close to the Whiggish notion of Parliament can do no wrong, or the elected body of the smaller peoples represented in the states could be trusted to protect rights. But it was the faraway federal government that could not be trusted not to infringe the freedom of speech, the freedom of religion, the freedom to bear arms, and so forth. And and I do regret, in fact, only much later in the case law of the Supreme Court did the Bill of Rights become incorporated, specifically into the 14th Amendment, as setting a standard for the rights which states could not trample on, because it did become clear, especially with the history of slavery and the aftermath of the Civil War, that the states could actually no longer be trusted to be sources of equality for their own citizens, and the federal government had to be itself, the federal constitutional order had to be itself a source of that equality. But as to whether the Bill of Rights implied itself that there was a notion of, there's already a notion of U.S. citizenship at the time of its promulgation, by which citizens and not merely people were guaranteed equality. That's very difficult to say. Personally, I don't read a concept of citizenship into it. I don't read a concept of citizens as enjoying equality into it. There was, in the early years of the constitutional order, it was very much the question as to whether the framers were believers in rights for citizens or more sort of general human rights for all inhabitants. I will end my answer there.
Okay, thank you very much. I now welcome the following opponent, Professor Gareth Davies, who's Professor of European Union Law at the Free University of Amsterdam. You have the word. Thank you.
Thank you very much. This is a very interesting book and very well written, and I very much enjoyed it. You suggest that at the heart of citizenship should be not allegiance but equality, and I think that's a great idea. It's an idea that even if one doesn't agree with it, it repays thought and it deserves to have wide discussion, and I hope that it does have that in the literature. And using that as the frame for your book, you're able to come to the conclusion by looking at the equality aspects of union citizenship that it's really quite a robust creature. And part of that, if I've understood it correctly, and I think I have, is it's not just horizontal rights but also vertical rights. And I now want to ask you a dishonest question about this, contrary to your request at the beginning. I'm not sure if it will lead to disorder. We will see whether it does or not. Dishonest in the sense, I think you've been a bit perhaps too upbeat about union citizenship, and so I want to be a little bit more downbeat than I perhaps believe in order to push you to defend your position. And firstly, one point is, are these vertical rights really different conceptually from the horizontal rights? When you give migrant citizens special privileges to bring their families and so on, and we know what those privileges are, you can conceptualize that as really just substantive equality, can't you? They start from a different position from the sedentary citizen. You can just see this as an extension, a working out, an elaboration of substantive equality, as we see in so many directives and all kinds of social rights. Do they really deserve to be treated as conceptually different categories? Now, the thing is, if they do, which I think you suggest they do, doesn't that lead you into a terrible problem? Because if it's not just substantive equality when you give people vertical rights, it's not just giving migrants, in a way, the same quality of life as sedentary people, then you are really creating a privileged group. And my substantive question is, what gives that the right, or what makes? Does this deserve the name citizenship? I mean, sure, you can stick a label on it, but citizenship has a meaning. We kind of understand what it is. What are you really doing here? You're taking a group of cosmopolitans, as I say, those with cross-border lives, even if they don't themselves. You're taking a group of cosmopolitans and you're giving them a different, separate, and largely privileged status. That small, 5–10% of Europeans, and others who stay at home don't have that status. In what sense is this really a citizenship for all Europeans? If citizenship is a form of membership, which you seem to imply really, the equality idea, and most people, it's a kind of membership of something, some kind of polity, you refer to medieval times, wouldn't you come to the conclusion that cosmopolitans in Europe are members of a different club from those who are non-cosmopolitans? You could say stay-at-homes are citizens of the member states, migrants or cosmopolitans are citizens of the Union, but they're not actually overlapping citizenships, they're quite separate.
Highly esteemed opponent, hooggeleerde opponent, thank you for your kind words and for your excellent question, of which I was already formulating my answer as you were asking it to me, because I could guess exactly what the thrust of your question was. That is very interesting. Yeah, I admit I've not been always the most fastidious about making a distinction between formal equality and substantive equality. That is sort of one of the, in order to pull together my argument, perhaps I sort of somewhat glibly skip over that. But that's a very interesting, yeah, that is in fact a very interesting question. I say, in particular, with the rights of mobile EU citizens to bring their family members with them, that the original intention of that, when it was introduced in 1960, well, when it was really introduced in 1964 with the Freedom of Movement of Workers, was in order to enable the integration of mobile citizens into a host member state. The idea was it was to render them substantively equal. For instance, if a French citizen coming to the Netherlands was free to bring his Senegalese spouse with him, that would make him substantively equal to a Dutch citizen who, as a matter of course, had the right to live a life together with his or her Dutch spouse. So that of course has created numerous problems, not least the problem of reverse discrimination, which I believe is what you're alluding to. Indeed, then it becomes it's a very interesting question that I have, that I'm at pains, to explain to my own clients all the time, to explain to my Dutch clients who come in. Well, actually, it's more difficult for you than it is for your French neighbor to bring in their family member, and why that is, and how that works. Indeed, this has opened up, the problem of reverse discrimination has opened up something of a yawning gap between the privileged cosmopolitans, the privileged citizens who are free or who are in a position to make use of the freedom of movement of persons, which one could call it an elite, of course. One thinks primarily of the expats and the students making use of the Erasmus programs being this class of privileged EU citizens who gains right from making use of the freedom of movement of persons. But as former Advocate General Ad Geldhoed also noted, the freedom of movement is largely referred to the uppermost classes and the lowermost classes, where it's the middle that is sort of, the lowermost classes who can do manual labor in other member states is also sort of privileged in this way, while it's the middle who might have a sort of language-related but not extremely elite skill set that is then effectively barred from making use of the freedom of movement. And yes, that is very much the problem, that there's been a misunderstanding that EU citizenship, or of course, some people misunderstand the project of EU citizenship as trying to create a sort of identity, a sort of common political or cultural identity of being European. But the unfortunate thing about that is that it has indeed been limited to a certain elite of cosmopolitans, which is why what does cause me to be upbeat then at the end of my book are the developments in Rotman, Risemvano, and Alokpa, where this is at least the first time that you see a certain class of very vulnerable, sedentary stay-at-homes, children, do start to derive rights of equality from EU citizenship, and I can only hope that it will spread out like an oil stain from there.
Thank you. Your next opponent is Professor Ulrich Jesuron de Oliveira, who's Professor Emeritus Migration Law at this university. You have the word. Thank you.
Mr. Candidate, it's with great interest and what is more, with pleasure that I've read your vividly written doctoral thesis. Union citizenship is one of my favorite topics. Elusive as it is, its development, its shape, is as ungraspable as that of the European Union itself. What I want to discuss with you is the so-called internal case and the concomitant reverse discrimination. In your terms, the boundaries between primary and substantively secondary union citizenship. I have a slightly different angle from Professor Davis, as I will show. In private international law, we are familiar with the distinction between internal cases and international cases. Here too, there is discussion about the way to draw the line between the two types. Is it a purely geographical criterion that dictates? Do the spatial characteristics of the case in hand dictate its label as internal or international? Or are there possibly extraterritorial claims of the rules of the states involved to govern the case decisive? Similar questions can be asked concerning the EU internal case. A geographical answer encounters paradoxes. The internal market is defined as an area without internal frontiers in which the free movement of persons is ensured. How is it possible to define from the angle of union law an internal case in terms of non-existing internal frontiers? So I submit that the distinction between an internal case and union cases must be made, and is in fact made, by referring to the desire of union law to be applied. Already in Morson and Janjan, 1982, the court stated that the matter depended on whether it may be inferred from the context of the provisions and the place which they occupy in community legal system as a whole, that the case had to be treated as an internal case or as a community case. In more or less the same wordings, this is repeated as settled case law in METOC. The doctrine of the deterrent effect of reverse discrimination is a case in point. Doesn't the deterrent effect of various municipal measures shy union citizens away from using their freedom of movement and thus bring them under the protection of union law? Staying put in one's own country is obviously not the criterion. You confess, discussing METOC, that you have skipped over some of the more abstract constitutional elements of this decision. I think that is a pity. I submit to you that the whole chain of decisions concerning the internal case is to be understood as primarily a constitutional issue between the Union and its member states. Who is boss around here? The gradual reduction of the area of the internal case is due not only to the internal logic and paradoxes of the Union legal system, but in part as well to a constitutional struggle between the Union and its member states about their competences and jurisdictional boundaries. Your 4 forms of equality analyze and describe this process, but do not much in explaining the dynamics of the development. To recap, I put it to you that an explanation can be found, at least in part, if the dwindling of the internal case is seen as a result of the battle between the Union and its constituent parts, decided by an institution, not exclusively, an institution embedded in one of the combatants. The line is drawn by power, not by factual features of the case. This is a tricky topic, so I know, so I would welcome almost any reaction.
I would invite you to be succinct in your answer. Thank you.
Highly esteemed opponent, hooggeleerde opponent, thank you for your kind words and for your very challenging question. Indeed, you say that the dwindling internal situation is really a dynamic of power. I agree. Indeed, I probably could have spent more time in exploring this dynamic. Immediately, the article by Steve Pearce about METOC, in which he described it precisely as constitutional struggle between the union institutions as the member states, and the member states came to mind. It is a very interesting point, and immediately the comparison with the US case comes to mind, because interestingly enough, as I analyzed in my analyses of the cases Edwards versus California and Mitchell versus United States, and later Boynton versus Virginia, funnily enough, one of the paths of moving up the frontiers of equality for US citizens went actually via the path of, and also the promulgation of the Civil Rights Act, last but not least, in the 1960s, went through the path of the federal legislature and the federal constitutional legislature and the Supreme Court constantly stretching the cross-border area, and that citizens enjoyed equality within the realm of federal law wherever there was a cross-border situation. And this could only happen, of course, in the face of effectively the defeat of the southern states, or at least the disappearance of the fear that the southern states would start a second civil war if this was forced upon them. It was sort of confidence and, the experience of 2 world wars that gave the Supreme Court and the congressional legislature the courage, as in the Civil Rights Act, to basically say any business that is engaged, that is selling any kind of products that comes from another state, or any business, any hotel that has more than 5 rooms, or any gas station that sells gasoline that's imported from another state, is involved in interstate business and therefore falls within the ambit of federal law. That was a quite bold move, but yes, it took a century before the federal legislature had the courage to do that, and that can indeed be explained in terms of power, a power struggle that was decided in favor of federal rights.
Thank you. I would introduce the next opponent, Professor Betty de Hart, who is Professor of Migration Law at this university.
dear candidate, dear Jeremy, I won't repeat the compliments of the former speakers due to lack of time and immediately go to my question. One of the things that I valued very much is that you pay ample attention to the issue of race and citizenship, an issue that is understudied in my opinion, and that European legal scholars often consider as an issue for American legal scholars, but we in Europe have no problem with race. So I especially appreciate that. But my question is somehow related to that, but in a different direction. You write that you were inspired by critical legal theory. My question relates to this. Throughout your PhD, you provide a lot of proof, not only of the relevance of race, but also of gender. Although it is a bit tedious to raise the issue of gender as a female scholar in a predominantly male commission of your PhD, but I think that your PhD leaves me no choice but to do that. You make clear that historically the rights of citizenships were only for white male property-holding male citizens and not for women. As authors like Nancy Cott and Linda Kerber explain, women's relationships were determined through the husband, and this determined their relationship with the state. Married women could not freely move, they could only be moved and follow their husbands. Also, in your discussion of EU case law, it becomes clear how women were predominantly granted a position in EU law as caretakers of children, for instance in Chen and Carpenter and other case law that you discuss. I would have expected you to pay more explicit attention to gender, as in critical legal theory, an intersectional approach of both gender and race is very common. And in the EU citizenship literature, feminist scholars have written extensively on the gendered nature of EU law and EU citizenship. In short, there's a lot of gender in your book, but nowhere you explicitly address the role that gender plays, and I want to invite you to do that here on the spot. Not to explain why you did not do that, because that's not that interesting, but to invite you to do that here and address the issue of how gender, adding gender, could complicate your analysis of EU citizenship law and the case law that you have studied.
Highly esteemed opponent, hooggeleerde opponent, thank you for your kind words and for your very challenging question. I admit, indeed, I touch on the issue of gender in my thesis, but at places in a very superficial way. For instance, when I'm reviewing the case of Unger, which I find still very curious in this time and day, that at the time the decision of the European Court of Justice was published, it was published as Hoekstra nee Unger. The person involved was identified by her husband's name. But of course, that was only a very superficial mention. And indeed, the issue in Chen and Carpenter, in the role of women as caretaker for the children, or in Alokpa for that matter, where it can also be interestingly contrasted. For instance, I can already off the cuff say that can be contrasted to, for instance, Ruiz Zambrano, in which the focus was on the father of the children, and it was interesting that he was not presented so much as a caretaker for his children, although, of course, the mother was implicitly a subject of the decision to be a caretaker for the child. But he was presented in the light of being the breadwinner for the children, because it was about his right to have a work permit in Belgium. So it was presumed that the mother would stay at home and take care of the Ruiz Zambrano children, while the father, Mr. Ruiz Zambrano, was his main interest, or the children's interest through him, was for him to be able to be an earner or a breadwinner for the family, which indeed does imply a rather conservative gender norm imbuing these decisions of the court. Suppose Yeah, I suppose that's the one issue that comes most to mind of the decisions that I named. So I'll conclude my answer there.
Thank you. And the final opponent is Professor Ernst Hirsch-Berlin, who is Professor of Dutch and European Constitutional Law at Tilburg University and Professor of Human Rights at this university. You have the floor.
Thank you, Rek. My congratulations in the first place with your extremely interesting and rich work. I have a question on the significance of portability of citizenship. It appears to contribute to legal equality compared to the limitations of a merely vertical relation. The fugitive slave cases in the United States and the social security cases in the European Union confirm the relevance of a portable union citizenship. Now, what about invoking the duties of a citizen by the state or union concerned when he or she has moved outside the territory? Since we live in a world where a growing number of people is on the move more or less frequently between different territories where they are citizens, multiple citizenship is becoming more and more, so to say, their natural condition. But living in a world with multiple citizenship becomes less pleasant when a state tries to extend an exterritorial grip on their citizens, like the United States is doing with respect to the enforcement of its tax law, or Turkey, for instance, with respect to military service. Therefore, my question, does portability in such questions, in such situations, still contribute to personal freedom, or could it become detrimental to equality with co-citizens living in the same country?
Highly esteemed opponent, hooggeleerde opponent, thank you for your kind words. I'm very honored, by the way, that you participated in my commission, and thank you for your very challenging question regarding portability of citizenship. Of course, of the 4 forms of equality that I analyzed as being prominent in citizenship, in the order of uniformity, I say the first most uniform form of equality is a uniform equality over an entire territory. The second is non-discrimination, meaning a uniform norm of equality within a given state. Third, a cross-border norm, a norm of equality for citizens making use of freedom of movement. And fourth, portability of citizenship, which is an equal right for citizens to bring the rights which they gained in a given state to and enjoy them extraterritorially. But you've extended that again with the dimension of duties. Of course, equalities can, I chose for the term equalities in my thesis and not necessarily rights, because equalities can also be burdensome, as, for instance, in the fugitive slave clause in the early development of the United States, where the one equality that African American citizens enjoyed was the equal liability, maybe not a duty, but the equal liability to recapture, to being claimed as a fugitive slave. So that indeed does create extremely problematic, I do say, in general, I do come to the conclusion that portability, in my view, does not necessarily figure so prominently in federal citizenship as a form of equality, because it is the least uniform form of equality. I give the example of 13 theoretical states with 13 theoretical norms that citizens can take with them to other states. But then that's 13 theoretical norms of equality, but then it also has to be multiplied by the way in which those norms of equality are recognized in the destination state, whether by the rules of comity and the rules of public order exceptions, whether the destination state even chooses to recognize that, or if that's considered to collide, creating thereby 169 possible permutations of equality. Or maybe I had the math wrong. I had a friend of mine who's a PhD in mathematics, who I hoped would be here today, but he wasn't able to make it. So, indeed, yeah, and the question of extraterritorial duties of the citizen is indeed a very nettlesome one. Indeed, the problem that is becoming very prominent now which I am at least theoretically confronted with. I have to take my head out of the sand, is the extraterritorial taxation authority over US citizens. But also, you see that in the introduction of EU citizenship, I highlight the role of Spain and Felipe González in suggesting EU citizenship precisely as a way to introduce a form of duties for EU citizens or burdens for EU citizens who are staying outside of their own territory. I'll finish very briefly, particularly because Spain was rather annoyed by the problem of ETA soldiers fleeing into other member states and wished to prevent them from being able to enjoy asylum there and wanted to impose a duty on them of being extraditable.
The discussion is closed now. I request the candidate to read the second part of the formula.
Having thus concluded the defense of my thesis to the best of my ability, and pending the decision of the doctorate committee, I should like to express my sincere thanks to my highly esteemed supervisors in particular, as well as to those who have so courteously brought forward their criticisms, and to all who have honored this ceremony with their presence.
The committee retires now for deliberation.
And applause as well for the tailor, my life partner, Stefan, who spent every free minute of the last 3 weeks working on making my tailcoat suit.
Esteemed candidate, after due consideration of the thesis you have submitted, we have decided to grant you the doctoral thesis degree. Professor Eisbouts, also on behalf of Professor Schrouwen, is authorized to confer this dignity upon you in the customary fashion.
Most willingly, I accept the task assigned to me by the Rector Magnificus of this university. By virtue of the power conferred on us by law and in accordance with the decision of the Rector and the Doctoral Board of the University of Amsterdam, I hereby confer upon you, Jeremy Benjamin Bierbach, the degree of Doctor, and grant you all the rights pertaining to
by law or custom. In evidence thereof, you'll be presented with a degree certificate signed by the rector and the supervisors and everyone else present in the room and confirmed with the Great Seal of the University. Having thus fulfilled the task assigned to me, I have the honor of being the first to address you as Doctor, and to congratulate you with the dignity conferred on you. Dear Dr. Bierbach, dear Jeremy, dear parents, Stefan, dear audience, every PhD history is different. Few have the special flavors of this particular one, this history. It eschewed all standards and routines. It was now eruptive and then still for a while. It went from himmelhoch jauchzend bis zum Tode betrübt. And it was full of surprise from the beginning to the end. But that's what you have with the creative act. And now that this creative act is accomplished, finished, crowned with the title, allow me some thoughts on its particular hardship and pleasures. From our point of view, our supervisors, the three of us, Annette Schouwen, Jan Herman Reesman, and me, who had the pleasure to be involved in this. And about special responsibilities we were entrusted with by some extraneous authority, as I shall disclose towards the end of my speech. Our history starts in the academic year of 2006 and 7, when you, Jeremy, you took the class of European Constitutional Law in our master's program, a breeding ground of many talented young scholars. We see them all over the country, in Europe now. A bright student, the one you notice and the one you want to stick around. Fluent in Dutch and more articulate even in Dutch than many native students. Bright, almost embarrassed by his many talents, Jeremy, you. So we wanted him in, but how to frame or tame this somewhat unruly intellect? That's the theme of this history. We decided to enlist you, Jeremy, as an editorial manager of the journal. And together with this, we suggested you write a PhD, and we even offered, would you believe, a PhD position to cap the two other elements, to make it a perfect package, tried and trusted by former doctoral students. But Jeremy bluntly refused that position. Why? Because it was meant for him too much comfort. It was too easy to sit in the university and to give up his several exciting legal freelance positions, and especially the own business as avocado legal. Now let me tell you a secret, a non-secret about this thing. Jeremy was then no certified attorney at law, no advocaat. He could not call himself an advocaat, an advocate, nor abogado, nor anything else of the variety of names you have in Europe. And he found the only assembly of characters sounding like advocate, which was not legally protected for the status. Why? Because it was a fruit. Avocado legal, so a legal fruit. And then, of course, he invited all the battles with the powerful profession, because, you know, they said he was trying to circumvent their certification procedure, etc. And he won and became the nation's among the nation's great specialists of EU citizenship law in a practical perspective to get people into the country. So he came from America, came into Holland, and then brought in others into this beautiful European community. Well, the first thing we had to do is then, since he did not accept the position, which would have been, would have meant a guaranteed lifelong scholarly career, we had to press him to regularize this legal situation and to get rid of the abogado legal thing and become a lawyer. And this happened. And we allowed him to do that. Not only that, we pressed him to do that. But how about the PhD? Could this remain a semi-certified operation? Well, it had to be done. It had to be pressed also. Intellectually, of course, we were in a luxury position as supervisors. We did not have to inspire, but we only had to contain this unruly set of talents and ambitions. We called it the Operation Bridling Bierbach. We got him a scholarship for a day a week, nailing him down to a strict commitment known by the name of the historic bill, which you may remember, and which I have here. Historische Urkunde. Today, on this 20th of April, 2009, I established that the subject of my dissertation research will relate at its core to a comparison between EU citizenship and US citizenship starting from Federalist Paper number 42. EU citizenship will be revealed to be of a nature that is ever intermediate and not necessarily intended to arrive at a solid goal. That was the original plan, but there was a plan, a contract, a document, a charter that you nailed yourself down to, which was very good. It worked. Then, of course, that as to form. Then we had to find the substance. Let me see where I am. From then on, when this started, at irregular intervals, we would receive chapters, now about some historic aspect of US citizenship, then about some case of EU citizenship. Each of these chapters extremely inspired, well-researched and well-written and original, a joy to read. He proved to be an eruptive writer, Jeremy, you did. But what about the overarching order of the structure of this whole thing? It was eruptive, as we said, still needed to be contained. Then Annette Schouwen came in and was added to the team of coaches, and we held a great number of memorable brainstorming sessions to bring all these heteroplite elements together. And we knew that the reading was fantastic, the text was great. The only thing we had to do is bind this whole thing together. And we knew there was a strong latent unity, which was in Jeremy's motive of action, which had to be brought out. And each time when we had these sessions, and then a meeting point was found by Jeremy, we remember his face, we remember your face, lighting up like the sun from behind the clouds. He said, yes, that's it. This is how we're going to do it. And we went ahead. Now, the result is this book. As Ernst Hirschwallin aptly said, it's a rich book. It's a very rich book. It's historic, legal, political. It's brilliant, and it's lively. And it's such a pleasure to read, and even looks so enticing that you forget it's way oversized, and that still it will claim its rightful place in the studies of EU and US citizenship, which is a very important thing. Now finally, about the special responsibility we were given. At some point, I think 3 or 4 years ago, we met the doctor's mother. Is she here? Yes, there she is. We haven't met before, we can't. And who assured us that Jeremy, as an unruly person and as a scholar of his kind, was so much better off in Europe than in the US. Think of a mother coming to say, your son's better off with you, with your kind, than with our kind. I think We then understood what you meant, dear mother of Jeremy, and we've tried to help him to his place here, now finally insured as a certified, almost, advocate, and now a fully certified scholar, and to do all these things that he wishes to do in a fully certified way. Jeremy, my last words, you've now found a way to our minds, of all of us, through your book, and to our hearts, and we do hope we keep you on this continent. Please listen to the formula in which the scholarly discourse or narrative has put this. It's as follows. Let me see. Yes. Dear candidate, no, dear doctor, regard the obtained dignity as an honor and a privilege, and never forget the attendant responsibilities which you now bear towards society and science. I have said.
It is a very pleasant duty, most learned scholar, to congratulate you, also on behalf of the Doctorate Board of the University of Amsterdam, on this newly acquired honour. And hereby I declare this ceremony closed. Thank you.